Okay, we're here this morning continuing from a hearing on Saturday. There was a petition 2 filed on Friday afternoon alleging some pretty serious things as it relates to injuries on the youngest child, and I'll be going through that here in a few minutes after appearances.
Good morning, Your Honor. Nicole Underwood, lawyer regarding an item for minor children.
Good morning, Your Honor. Troy Tipton, appearing on behalf of the Department of Health and Human Services.
Karen Trout with DHS.
Michael McFarland, representing mother. Please identify yourself.
Robin Hardy.
I'm Lee Heiss. I'm filling in today for Katrina Dumont, representing Tyler Long.
Thank you. I confirmed with both of your clients yesterday, counselors, that Saturday, I'm sorry, that neither of them had any Native American heritage or any reason to believe that they qualified for evaluation in that respect. Is there any different information on that this morning?
I do, Your Honor. My client's father indicates that there is some Native American heritage. It's so far back, but still, I think we need to reveal that to the court.
Thank you. All right. Ms. Trout, we'll trust you to follow up on that.
Your Honor, may the record reflect that Tyler Long is here with me today, and I have no different information today about the Native American.
Thank you. All right. The other reason we adjourned from Saturday was, of course, to allow Mr. McFarland to join us on behalf of Ms. Hardy, who requested that the petition be read into the record. So I'm ready to do that now, if that is still your position, Mr. McFarland.
Yes, please, Your Honor.
All right. So why don't we just take care of that right off. It's petition 2. Regarding the 2 Long children, indicating that Tyler Scott Long and Robin Lorraine Hardy are the legal parents of these 2 minor children. There is an indication that there's one other case that applies to this family regarding the older child. But other than that, there does not indicate any additional cases, and that's page 2, paragraph 3. Paragraph 4 indicates the violation of the statute under MCL 712A.2b. Specifically, the paragraphs relevant are the parent or other person legally responsible.
Your Honor, my client indicates she could.
Sorry.
Okay, I'll try to speak up.
Thank you.
The allegation of the violation of the statute is that the parent or other person legally responsible for the care and maintenance of the children unable to do so, neglected or refused to provide proper or necessary support, education, medical, surgical, or other care necessary for the children's health or morals, or that he or she has subjected the children to a substantial risk of harm to his or her mental well-being, or he or she has abandoned the children without proper custody or guardianship. The other paragraph applicable indicates an allegation that the home or environment, by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent, guardian, or non-parent adult, or the custodian, is an unfit place for the children to live. Thank you. Paragraph 5 is checked, indicating the reason.
Your Honor, I'm sorry, but my client does have a learning disability. She's asked if you could slow down just a bit so she could process it.
I'm sorry.
You'll have some time to go over it with her after the hearing, Mr. McFarland. There's 6 pages of this, 4 pages to the addendum and 3 pages to the form, so technically 7. So I am reading it into the record for her benefit, but we only have an hour this morning, and I'll welcome you to chat with her about it at a later time as well.
Absolutely.
Because I'm not going to take the time to go through all of the allegations and answer questions. That's why she has you.
No, that's not what she wanted.
Okay.
Thank you.
Paragraph 5 indicates the reasons why it's contrary for the welfare of the children to remain in the home, and that is in the first amended petition attached. Paragraph 6 is checked, indicating reasonable efforts made to prevent the removal of children were included in the amended petition, which is the attachment. Paragraph 7 also indicates specific allegations are contained in the amended petition, which was attached. There's a request to issue an order removing the children from the care of the parents, which was authorized again last Friday night. The confidential case inventory does reference the other DC case 2019-46309, and the addendum indicates as follows, beginning on page 1 of 4, addendum to petition for emergency protective custody and jurisdiction as to respondent parents, jurisdiction and venue. 1, Robin Hardy is the biological mother of the subject minors. 2, Tyler Long is the legal father of the minors, Aaliyah Long and Rowan Long. Paternity is established by an affidavit of parentage, AOP number 2024-024463 and 2019-007850. 3, the subject minors may be members of, eligible for membership in a Native American tribe or band. Robin Hardy was asked and indicated she and the subject minors have Native American heritage. Subparagraph 3A, based on the information provided by Robin Hardy, a DHS 5598 was completed and mailed to the BIA, which is the Bureau of Indian Affairs. Completed certified mail receipts are attached, but no responses have been received. Paragraph 4, the subject minors are residents of Lenawee County, Michigan. The subject minor RL is currently located at Mott's Children's Hospital. The subject minor AL is currently at Clinton Elementary School. Paragraph 5, the incident of alleged abuse or neglect occurred in Lenawee County, Michigan. Factual allegations. 6, neglect, physical and medical. A, on or about 11/20/2024, CPS received a complaint alleging concerns of failure to thrive of the youngest child of Robin Long. This was not assigned for an investigation, but sent to the ongoing worker to address. B, on or about 12/12/24, CPS received a complaint alleging physical abuse of the youngest child by Robin Hardy and Tyler Long. C, that child was evaluated at the University of Michigan Mott's Child Protection Team. D, it was noted that the child has a significant medical history of prior poor weight gain. At his 2-month well visit, he was 3 months old, and that's in parentheses, on 11/12/2024, Dr. Bakshin noted that the child had skin lesions on his abdomen, back of his left upper arm, and left side of his back below his shoulder blade, concerning for bruising. E, the child subsequently switched to a PCP at ProMedica Physicians Health Specialist of Lenawee. At the child's first visit to the new PCP, he was found to be underweight and have poor weight gain. F, the child returned to Trinity Health and was evaluated by Dr. Bakshin for his 4-month well visit on 12/12/24. Dr. Bakshin noted that the child's prior concerning skin findings had resolved, supporting that these previously noted skin findings were most consistent with bruising. The child was then referred to Mott's CES due to suspected physical abuse and further evaluation and management. G, a skeletal survey was completed which identified a healing left mid-posterior 9th rib fracture. No drops, falls, or other trauma sustained by the child were reported by Ms. Hardy to explain the child's rib fracture or prior bruising. Furthermore, Ms. Hardy denied that neither of the family's 2 dogs or the child's 6-year-old sister could have harmed the child in any way. H, it was noted by the doctor that the child's fracture is a fracture type that is highly specific for physical abuse. The child's rib fracture is healing, indicating that the fracture is at least 10 to 14 days old. The child's rib fracture is not a birth injury. 2, Tyler Long has no CPS history as an alleged perpetrator. 3, Robin Hardy has the following CPS history. Subparagraph I, 3/6/2019, category 4 for physical abuse. Victim was the older child of this case. Perpetrator was identified as Robin Hardy in Lenawee County. Subparagraph 2, 9/22/2020, a category 3 open and closed for improper supervision. Victim again was the older child concerned in the jurisdiction of this case here. The perpetrator was found to be Robin Hardy in Lenawee County. Subparagraph 3, 10/26/21, a category 3 case, physical neglect, improper supervision. Victim, the oldest child, AL. Perpetrator, Robin Hardy, Lenawee County. 4, subparagraph 4, 9/20/24, category 2 for physical injury, threatened harm of placing a child at unreasonable risk. Victim, the youngest child in this case. The younger child, and the older child. Perpetrator identified as Robin Hardy by Lenawee County. Subparagraph 3B, Tyler Long has the following criminal history. Subparagraph I, January 24th, 2012, ordinance violation, assault or assault and battery. Pled guilty, 18 months probation, fines and costs. Subparagraph 2, 11/7/13, attempted misdemeanor police officer fleeing 4th degree vehicle code. Pled guilty, 24 months probation, fines and court costs. 3, 9/23/13, misdemeanor larceny, $200 or less than $1,000. Pled guilty, 24 months probation, 10 days in jail, fines and court costs. Subparagraph 4, 11/15/18, misdemeanor operating while intoxicated. Pled guilty, 12 months probation, fines and court costs. Subparagraph C, Robin Hardy has the following criminal history. I, 6/22/23, misdemeanor assault excluding sexual. Statutory citations. 7, required petition. This is a mandatory petition under Child Protection Law, Section 8D1E, MCL 722.628D1E. Paragraph 8. Statutory grounds for adjudication. Based on the above stated allegations, jurisdiction is proper under the following subsection of MCL 712A.2B. The child is under the age of 18 and A1. The children's parents, when able to do so, neglects or refuses to provide proper or necessary support, education, medical, surgical, or other care necessary for the children's health or morals, who are subject to a substantial risk of harm to their mental well-being, who is or are abandoned by their parents, or who is without proper custody or guardianship, and or D2, the children's home or environment with respondent parent by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent is an unfit place for the juvenile to live in. 9, statutory grounds for removal. Based on the above stated allegations and pursuant to the following subsection of MCL 7128.13A, removal of the children from the respondent parent's custody and care is necessary. And A, 3, releasing the children to the non-respondent parent under the supervision of the department is reasonable and necessary for the children's physical health or mental well-being. B, 4, order the parent, guardian, custodian, non-parent, adult, or other person residing in the children's home to leave the home and accept as court orders not to subsequently return to the home as all of the following exist. 1A, a petition alleging abuse of the children by the parent, guardian, custodian, non-parent, adult, or other person is authorized under MCL 712A.13A2. B2, B, there is probable cause to believe the parent, guardian, custodian, non-parent, adult, or other person residing in the children's home committed the abuse. B3, C, the presence in the home of the person alleged to have committed the abuse presents a substantial risk of harm to the children's life, physical health, or mental well-being. C, 9, placement of the children into foster care is necessary. A, custody of the child with the parent presents a substantial risk of harm to the child's life, physical health, or mental well-being. 2, B, no provision of service or other arrangement except removal of the child is reasonably available to adequately safeguard the child from risk, as described in subdivision A. 3, C, continuing the child's residence in the home is contrary to the child's welfare. Roman numeral 4, D, consistent with the circumstances, reasonable efforts were made to prevent or eliminate the need for removal of the child. Roman numeral 5, E, conditions of child custody away from the parent are adequate to safeguard the child's health and welfare. Relief requested. 1, authorize this petition for emergency protective custody and jurisdiction as to respondent parents, Robin Hardy and Tyler Long. 2, issue an order removing the children from the care and custody of their parents, placing the children in the care and custody of the department. 3, take jurisdiction over the child pursuant to MCL 712A.2B1 and 2. And 4, set this matter for an adjudication trial. Respectfully submitted on 12/13/24 by Troy Tipton and Hannah Trout for Michigan Department of Health and Human Services, Lenawee County. All right, counselors, your clients both confirmed also on Saturday that they had received a copy of the petition. Are there any other cases other than the child support case reference for the older child, like a guardianship or child support, custody, any other cases that concern these children?
Client indicates no.
My client is not aware of any other case.
Thank you. All right, you were both clients were informed that they are entitled to an attorney, which is why we have 2 attorneys from the Public Defender's Office here today. If either of you wish to retain your own private attorney, you're always be able to do that. That person will just have to get a hold of the attorney from the Public Defender's Office to ensure that they have what they need to perform as your new counsel. You also have a right to a trial by judge or jury on the allegations in the petition for purposes of adjudication. If you wish to exercise your right to a jury trial, that must be done in writing within the next 14 days. You have the right to seek placement of the children at this time. The right to an opportunity to admit or deny the allegations and make a statement of explanation. The court has already authorized the filing of the petition, and I look forward to any further argument on pretrial placement at this time. Mr. Tipton, has the department's position changed at all from Friday?
No, Your Honor.
All right. Ms. Underwood, if you would please give us any comments you might have.
Yes, Your Honor, thank you. After reviewing the petition and just looking at all the circumstances, I think we have a fine line here between the safety of the children, but also ensuring, I believe that Ms. Hardy is still nursing. So if there's a way that the children, and especially the youngest, can be safeguarded from any other risk of harm, but also be able to continue either providing milk some way for the child, that would be in the youngest best interest. But at this point, I do believe it's in their best interest to be removed until we can further investigate what had occurred. Thank you.
And would you be willing to talk with Hannah Trout on that and or potentially participate in a family team meeting about your concerns?
Absolutely.
Okay. Today, presentation or issues for today, Mr. McFarland?
Your Honor, excuse me. Just want you to listen.
Yes, sorry, she was.
My client, at this point is requesting a bench trial, Your Honor. I understand we have 14 days to change our mind, but at this point, we're requesting a bench trial. We are requesting that the child be returned home. I've been talking to the maternal grandfather, who indicates that there would be an adult other than my client with 24-hour eyes on child, Your Honor. We do have another physician who indicates no issues regarding the malnutrition of this child. We've not explored. We may possibly request an independent examination of the child. We are requesting that the oldest child, who was not found in this case to be injured, neglected, that child be returned home to the mother is our request, Your Honor. We're also requesting the same for the youngest child, with the understanding that there would always be an adult supervisor other than my client with the child. In the event the children aren't returned, my client would like as frequent parenting time as possible with the minor children, I should say. We would suggest that parents would be adequate supervisors is what we're asking for.
When you say parent, you mean the grandparents of the children?
I'm sorry, Your Honor, my client just said something.
That's okay. You asked that the parents be able to supervise. Which,
Yes, my client's mother is no longer working, so she's there 24 hours, Your Honor. And then when her father's not working, there are 2 adults in the home. That's true, Your Honor.
all right. I am listening as far as your request for potentially a child abuse expert to be provided to your client. And I am open and amenable to that, Mr. McFarland. I do know that that's been a difficult thing to find in the past.
You realize that?
So I will leave it to the Public Defender's Office to secure that particular expert and bring that person to us for approval as soon as possible. I'm looking at a trial date of February 10th, commencing at 10 a.m. And if you need additional time, of course, we can look at that.
Your Honor, I won't be available that day. If you're okay with the ongoing worker stepping in for me, that's fine. But I will not be available.
And I'm sorry, I do have a scheduling conflict at that time.
All right, I have Friday, February 21st, or the following 28th, if either of those days work better.
I can do either of those.
February 21st is fine with me.
That's fine.
All right, so we'll set the trial then for Friday, February 21st, commencing at 10 a.m.
Did you say 10?
Yes. I can do a pretrial on January 27th. Let's see. Yeah, that's the earliest I could do the pretrial. So January 27th at 10:30 or 11. Let's do it at 11.
Judge, I have an 11 o'clock, but the rest of the day I have open that day.
I do not. Looks like I already have this on my calendar for a bench trial on maybe petition 1.
Right,
for
but
Friday, January 24th?
I thought we removed that with the resolution that we had, Your Honor,
Oh, thank you.
extension of time.
So what I can do is turn that January 24th, 10 a.m. into a pretrial. Is everyone available Friday, January 24th for a pretrial at 10 a.m.?
Yes.
I am not, but given that it's pre-trial, I think the ongoing worker could step in for me for that.
All right, thank you. Who's the ongoing worker?
Megan McVeigh?
Thank you so much. Do we have Ms. McVeigh with us this morning? I don't see her. Okay.
We do. I
Right,
believe
Mr.
she's on Zoom.
Okay, all right. So who would be handling any family team meeting on any issues with regard to visitation and the concerns that the guardian ad litem has expressed this morning about the child's nutrition needs?
I think Megan and I can both kind of tag team on that.
All right, very good. Anything else to add to that request for family team meeting, Mr. McFarland?
Well, Your Honor, yes, there's a school class party for the oldest child. We also have Christmas coming up, exchange of presents, visits, there's birthday, January 23rd, that's coming up. Third, I guess. Third. So basically holiday events around the season.
Very good. I did note that they should address parenting time. I would hope that visitation for purposes of holiday would be included in that conversation. But thank you for placing that on the record.
Then our inquiry was, we know the court usually allows at least 3 visits, 2 hours per week, considering or placement.
Okay, do we have a worker that can speak to the initial plan for visitation?
Your Honor, may I articulate just briefly?
Sure.
Sorry.
No, that's all right. Go ahead.
You know, I believe in this case, there is a less restrictive environment for the children to live in. I'd ask you to consider that in the petition on page 3 of 4, 9A indicates that the statutory ground for removal is necessary, but it anticipated releasing the children to the non-respondent parent under the supervision of the department. It is my understanding that in the underlying petition that had been filed since September, that this father was released as a respondent in that case. I would like to indicate that he has his own independent housing and employment. He would like you to consider releasing the children to both him and the children's mother so that they would move this independent adult in so that there'd be a person around the clock. They have family support. At this time, the 2 children are placed with the maternal grandparents who have the ability to do this, although we all know that a movement of the children from their home in the middle of a school year near the holidays adds extra trauma. I would ask you to consider that my client, the father's father, took the children to school this morning. You know, there is this cooperation, there is this support so that the children have been under supervision since September 24th of 2024 at least, and the ongoing worker, Megan McVeigh, has approved the home. There is this allegation of these injuries and a break. And there are also defenses to that. I would ask you to consider that although there is not a response at this time that makes sense about how those injuries could have or would have happened, this is also very new. And these folks need time with their attorneys to talk back through what does and doesn't possibly contribute to these injuries. And we had an ongoing worker in and out, and these injuries are alleged to have been up to 2 weeks old, and they're 85% healed. There's a lot of medical information for the attorneys to go through, an expert to look at it. And in the meantime, I don't know that there's a reason the children can't continue in the least restrictive environment in their home. Further, although with reservations, my client is willing to have the children with the mother removed from the home if that makes any difference. This is what I note. mother was a respondent on the underlying case, and she was doing well. And she anticipated that because she had a THC, had used THC, and her levels were continuously reducing, that she would be released under that too. So I don't mean to indicate that she's a perpetrator, so she should be out of the house. But as an unmarried couple, he does own the house, and he is employed, and he would abide by any of the rules needed. So with that presentation, then we were going to talk about visitation next. Thank you.
My client would remove herself from that house, sure.
Well, before I forget, the issue of marijuana use that was raised in the first petition does affect the court's position on breastfeeding, Ms. Underwood. So if you could please make that part of the conversation during the family team meeting. I am not generally inclined to allow a parent to breastfeed a child who is testing for high amounts of, or any amounts of, really THC in their system, considering the possible effects of that on a newborn child. And in this case, we have an injury on top of that. So I would not be inclined to allow the mother to take that risk. So please take that into account when you're at the family team meeting. I'm sure there's drug testing that can be done in order to really inform better about that point. But I know I've announced that on the record in this file before.
If I may, Judge, I know that Ms. Hardy had been taking regular drug tests in order to show that her levels were decreasing, that she hadn't been actively using, which is, again, I have not had an opportunity to talk with ongoing worker about the status of those, but that can all be explored at the committee meeting.
Thank you. All right. So then visitation for sure will be something that we'll ask the department to do within the next 14 days on visitation, and to allow the parties to look at that between now and then. On the request for in-home jurisdiction, I would note that on this petition, both parents have been named as respondents, and the court did authorize that petition. So before I turn it over to Mr. Tipton, I do want to recognize for the record that Tyler Long has been recognized as a respondent in this petition, in addition to mother being recognized as a respondent under the current allegations. But as it relates to the request for in-home jurisdiction, Mr. Tipton, would you like to respond?
Your Honor, the department would object to in-home jurisdiction. As the court indicated before, the department did, make efforts to keep AL and RL home, and that was the whole purpose. Now we have these new allegations, well, at least one of the allegations, but of RL not thriving, but also we have allegations of unexplained serious injuries. So I do believe that placement of the children and with the relatives is the least restrictive environment at this time.
Did you want to say anything on that request, Mr. McFarland? I did hear your remarks that your client would be willing to vacate the home, but both parents are indicated as respondents.
Well, Your Honor, there is no allegation that the maternal parents were in any way involved, implicit, or responsible for the alleged injury. So we do think that would still be a viable option as to maintain stability for the kids so they're not traumatized by a new child. Let me just inquire if there's other family that might be considered. My client is indicating that the paternal grandfather would be a possible family placement rather than foster care. We'd like to have that explored.
Ms. Underwood, did you want to say anything about the request for in-home jurisdiction?
I don't think that in-home jurisdiction is appropriate at this time. Like I said, I think the allegations are pretty serious and those need to be explored further before the children are in home. I would be open to hearing a little bit more about if Ms. Hardy were to move to somebody's home with the children or have that closely monitored, but I'd really like to err on the side of caution at this time based on the additional allegations that have been brought forth while the children were already under the care and supervision of the department. Thank you.
I can't address that, Your Honor. If the court would just allow me a minute. My client would move out of her parents' house. And she's not living there now. And she would agree not to enter without permission of the agency. So therefore, there would be a permanent caretaker there in the maternal grandmother. The maternal grandfather would be there. This is the residence the kids are aware of. My client will not be there. And I can have grandfather testify today under oath that he would abide by that court order, Your Honor.
All right, Mr. Tipton, I would like to hear a little bit about the department's decision to utilize, it sounds like unrelated foster care rather than a relative placement. Is that what's happening?
The kids are placed
It
with
was
maternal
my understanding.
Okay.
It was my understanding that they were placed with relatives, Your Honor.
That's what I thought too.
Yeah.
Right, but we're indicating that this would be another option. That's preference for my client would be first her parents and then the paternal side of the family.
Is your client residing with her parents?
She is not, Your Honor.
Okay, I just wanted to be clear that at this time, the court is not authorizing that. Both children, as I understand it, are already placed with her parents. So
That's fine.
Is that okay?
that's where they're going to stay, assuming that the relative placement is prepared to follow the directives and orders of the court, as well as cooperate with the Department of Health and Human
Thank you. I
Services.
thought the foster care placement removal was on the table. If it's not, then thank you.
Okay. This was just a removal from the parents.
Just gonna say.
Okay, right, Mr. Tipton? Am I missing something?
No, Your Honor, that's correct.
Very good. Okay, well, that's good. Relative placement obviously has priority. Relative visitation is an option under the manual. Obviously, that's something that's being requested, so we'll add that to the list of things for the family team meeting. Breastfeeding and nutrition for the youngest child involving the mother if possible, given drug screens that allow her to support in that way. Visitation for the parents, and then also visitation for relatives should be addressed in that family team meeting. And I look forward to the updates at the pretrial. I do agree, based on my review of the petition, and understanding that this was initially an in-home jurisdiction case that looked like it was resolving. The initial allegations of marijuana use by mother had been resolving, which was great progress. And we were looking at dismissing the case. However, the allegations in this petition are serious. Obviously, there's a very young child that has injuries very indicative of abuse that have been evaluated by an expert. I look forward to appointing an expert to review their work as necessary. But those injuries did occur while the parents were under the jurisdiction of the court. They had the support of the Department of Health and Human Services. So I cannot find at this time that placement with the parents is adequate to safeguard against a risk of physical injury and injury to the mental health of the children based on those dynamics in the home. The injury of one child can easily be indicative of parenting that applies to all the children in the home, including the sibling that was living with the parents. So for all those reasons, I am denying the request for in-home visitation at this time. All right, if you need anything else between now and when we come back, I am obviously available to all of you for any filings. Is there anything else for the record this morning?
No,
No, Your Honor.